In states that want to prevent the children from undergoing the mutilation news, an appeal court has upheld Kentucky's ban on the mutilation of the children through the chemical castration and the physical mutilation of the children because Kentucky thinks, that that's bad. We shouldn't do the chemical castration and the physical mutilation of the children in Kentucky, and the appeal court has upheld these bans, as just being, logical and good sense. So let's learn a little bit more about the latest in Kentucky's version of this ongoing fight. Let's learn a little bit more. An appeal court Thursday night upheld the law in Kentucky and Tennessee banning the chemical castration and the genital mutilation of the children. In a 2-1 decision, the Sixth Circuit Court of Appeals 3-judge panel said the matter was one for the state legislatures to decide, not life-tenured judges constraining a difficult-to-amend constitution. So they think that this is up to the states, which of course makes sense in the first instance, because states, not the federal government, has what's known as police power, the general power to do stuff. The federal government does not have the general power to do stuff. The federal government is one of enumerated powers. The Constitution sets out the powers of the federal government, and that's all the powers that they have, as the 10th Amendment makes clear. Any power not given to the federal government is reserved to the states and the people, which means the general power to do stuff, otherwise known as the police power, is the state level power, which includes the regulation of the practice of medicine. So this is not a matter of the federal Constitution. This is just a matter of state choice and when it comes to the regulation of the practice of medicine, which makes sense from baseline federalist principles. The judge writing in their opinion, no one in the consolidated cases debates the existence of gender dysphoria, which is a mental disease recognized by the DSM as a mental deficiency, or distress caused by it. And no one doubts the value of providing care to children facing it. The question is whether additional treatments, such as puberty blockers, otherwise known as chemical castration, hormone treatments, and surgeries, otherwise known as genital mutilation, should be added to the mix of treatments available to those under the age of 17. Kentucky and Tennessee saying no, not so much. The judge is writing in their opinion that gender dysphoria is a relatively new diagnosis with ever-shifting approaches to care. As such, they said they wanted to be humble and careful about announcing a new substantive due process right or equal protection right under the U.S. Constitution, because the U.S. Constitution probably didn't have in mind the genital mutilation or chemical castration of the children as being a fundamental right. Just guessing, that's not probably what the founding fathers had in mind when they wrote those provisions, just on the off chance. And that there needs to be limits that hold elected officials accountable for these changes because, they're elected, not us. For these reasons, they reversed the preliminary injunction that had been issued in these cases, allowing those to go into effect in both Tennessee and Kentucky as a matter of their state law preferences. The decision from the Sixth Circuit Court of Appeals is the latest legal blow to 7 Kentucky transgender teenage plaintiffs and their families who had sued the state in May. The Republican Attorney General, who had fought for the ability to enforce the statewide prohibition, celebrated the decision, saying, "This is another day and another win for Kentucky kids." He added, "Our kids would still be under attack without the Senate bill, which he said protects Kentucky kids from the experimental sex change treatments, including the chemical castration and the physical mutilation." The ACLU, for their part, who loves the chemical castration and physical mutilation of the children, called the decision heartbreaking for transgender youth across the state, saying it ignores from medical experts and trial courts who agree the care is necessary, effective, and appropriate, and banning it undermines parents' rights to physically mutilate and castrate their children. I mean, direct the upbringing of their children. Oh, what a simple reading mistake I made. How silly. Kentucky's ban on the surgeries, hormone therapy, and puberty blockers for youth living with gender dysphoria has been in effect since July, after the provision became law with broad Republican backing over the veto of the Democratic governor. But the state legislature's like, screw you, we're going to make it law anyway. The ACLU and Center for the Gay and Lesbian Rights sued on behalf of 7 families. Kentucky plaintiffs are especially challenging the ban on hormone therapy and puberty blockers. What lawyers had argued that denial of such evidence-based care violates the 14th Amendment for equal protection because it discriminates on the basis of sex, which doesn't make sense, by the way, because they deny the care for both sexes, so it's not on the basis of sex. And also, it's reaffirming that sex exists as a biological reality. The ACLU had also argued it violates parents' rights to seek and follow medical advice, including the mutilation. More than 20 major medical associations signed on to a lawsuit in support of the plaintiffs. In their 35-page brief, which details clinical understanding for gender dysphoria, which is a recognized mental disease under the DSM, and effective treatment for it, the medical associations, including the AMA and American Association of Pediatrics, explain that BAM puts trans kids at risk of significant harm, saying, quote, the widely accepted recommendation of the medical community, including that of respected professionals participating here, is the standard of care is the genital mutilation and the chemical castration, apparently. But the states of Tennessee and Kentucky have some problems with that. A similar ban that made its way into Tennessee this year was promptly challenged by 3 plaintiffs and their families. In July, the same 3-judge panel denied injunctive relief. The decision, now made by the Sixth Circuit Court of Appeals, restored the ban on the care, and in doing so, consolidated Kentucky and Tennessee's cases into the same appeals process. Plaintiffs had asked the appellate court for an injunction blocking both laws. A preliminary injunction is only granted in extraordinary circumstances when it's clear that you're going to win, but not so much. So they didn't, put the injunction on the law. What's more, because so many states have begun passing laws restricting the mutilation and castration, a sweeping decision from the judiciary one way or another, preventing government bodies from further democratically deliberating these policies, was ill-advised. As close to 20 states have enacted similar restriction, judicial intervention to block the law would start grinding these laws all over the map as the states take their various positions. Given the high stakes of these nascent policy deliberations, the long-term health of children facing gender dysphoria, a recognized mental illness in the DSM, sound government usually benefits from more rather than less debate, more than less input, more than less consideration of far-minded policy approaches. So the federal judiciary taking note of their limitations, saying this is a matter of state practice when it comes to the practice of medicine and what kinds of medicine will and will not be permitted in the state, which has been a feature of state law basically forever. The judges continued writing that allowing the democratic process to exist is all the more critical in view of 2 looming realities in both cases. The concept of gender dysphoria as a medical condition is relatively new, and the use of these treatments that change or modify the sex characteristics through the mutilation and castration is even more recent. Keeping citizens and legislatures from offering their perspectives on high-stake medical policies in which compassion for the children points in both directions is not something federal judges should do without clear direction in the Constitution, which is a little hard to extract from language that was passed in 1791 that probably didn't deal with the hacking off of the bits of the kids. Thus, that brings us to the end of the story about the Kentucky ban on gender mutilation and chemical castration being allowed to go into effect, as well as Tennessee's ban on the practices. So some states have had their bans turned over by various courts, but not so much in the Sixth Circuit, which rules that this is a matter of state law. So the bans in Kentucky and Tennessee are allowed to go forward in their full force, preventing the kids from undergoing these often irreparable treatments and not allowing that to go forward. So that is the law as it relates to this. A good day for people who oppose the mutilation of the children. And that brings us to the end of discussion of this story.